Be agreed to.
Mr. Speaker.
I call the Honourable Member Andrew Little.
Thank you, Mr. Speaker. Appreciate the opportunity to take another call on the Trustee Public Trust Amendment Bill. And, sir, I want to take issue with some of the points made by the Honourable Judith Collins in her last address. And simply to say that, in fact, what was news in Ms Collins' presentation is that the application by Perpetual Trustee to the High Court has been in court for some time, because that undermines the case for urgency. We know that the application is there. We know that it's been prompted by the challenge that Perpetual Trustees face from the receivers, and that is entirely appropriate, and hopefully that piece of litigation will be a trendsetter, because for far too long we've had trustees of finance companies who have been quite happy to clip the ticket, earn their fees, but when everything turns to custard, they're nowhere to be seen. And so I congratulate the receivers, certainly, for challenging the trustees, because hopefully it's litigation like that that will start to lift the standard of those trustees. But that litigation, as the Minister has said, has been on foot for some time. So why hasn't her ministry, or why hasn't she, taken action before now? Suddenly we're presented with this impending crisis, because we are 3 weeks out or 4 weeks out from the actual trial and the application being heard in the High Court. Why hasn't action been taken before now? And I think that actually it is the fact that that application, those proceedings, have been on foot for some time, illustrates the point that we are making, is that the urgency is not justified, because those proceedings have been on foot for some time in relation to a trustee company that is the trustee for 22 other failed companies, about which no proceedings have been issued. So where is the urgency? There is only one case. And, sir, had this legislation proceeded in the proper way, with a date in it from which it would take effect, its jurisdiction would take effect, then we would have had the benefit of a proper process, proper scrutiny, and most importantly, the input of those in the sector, those experts, the professionals who are routinely dealing with this, so that we can fully understand the risks. Even the Ministry of Justice, in their regulatory impact statement, cannot tell us what the full risks are. They haven't had time. They haven't had time to engage with the professionals. They haven't had time to talk to others. And so we simply do not know. Now, the Minister is entitled to credit for taking an approach on the issue that is, at least from our point of view, a good approach. It is fair, it is proper, it mitigates the risk for the public trust, and therefore for the public purse and the public interest. It seeks to impose the cost where it properly belongs, and that is on the periphery of the finance sector. That is quite correct, that is proper. But actually our job when we stand here, and the Crown when they sit over there, their job is to protect the public purse to the best extent. Our job as a Parliament is to protect the public interest to the best extent. But actually we can't properly do that until we hear from those who have an interest in it, those who have a stake in it. That's the reason we have the sort of processes and procedures we do. That's the reason we claim to be democratic when we have select committees and we have input. Even in truncated select committee processes, we might just invite a select few that the parties can agree on, might have something useful to say over a couple of weeks. Even in a truncated select committee process, that would be of some benefit and some help to us. But that's not what we've got. We've got panic reaction, knee-jerk reaction, the claim that the floodgates will open when there's no evidence of that happening at all, and other means to mitigate the floodgate argument, but we're rushed into a panic action and we have no means of knowing whether what we're doing is proper or fair, or whether indeed we've taken account of all the risks. This is the problem. This is the problem that we face. And that's the reason, sir, why, notwithstanding that we support the policy of the bill, and we will support it, we do not wish to let it go by without putting firmly and squarely on the record our concern and our objection to the process that is being followed. It is simply unnecessary. It is simply unnecessary, and we don't want to be faced with this again when there is some other unforeseen litigation happening in that sector and a minister gets panicked and the whole House is thrown into urgency and rushed into this, and we don't have the benefit of full and proper and considered scrutiny, which is our job, which is our duty as public servants to the nation. So we have considerable anxiety about that, and it gives us no. We receive no assurance in the words of the Minister and the explanations such as she's given that this is necessary because of present circumstances. The circumstances, as we see it, are not as drastic as she makes out. One case, one piece of litigation that has been on foot for some time against a company that is the trustee for 22 other failed finance companies. No evidence or indication that there are 22 other proceedings in the wings, or indeed have been filed. No indication that of the other 38 failed finance companies and their trustees that there is litigation pending in relation to them. So we don't buy the argument that this is time for panic. To the contrary, even if this is a stopgap measure, even if we still have the Financial Markets Conduct Bill to come, this is not a reason not to give proper and due consideration to the full circumstances and the full issues surrounding this bill and what it is trying to address. So, sir, it is important that we get that on the record. Perhaps this can be a plea, a public plea to this Minister, who, frankly, unfortunately, regrettably, most that she touches tends to turn to custard, is that let's not be put in this position again, because it is not good for Parliament and its standing and the public respect, or the respect that the public ought to have of it, although, of course, that's been sorely tested because of members on that side of the House in the last couple of days. Anyway, so let's not be put in the position where we are compelled, because of the power of government of the day, to have to rush through legislation without a full consideration of its implications and ramifications. That is our issue. Perpetual Trustee is the only trustee company facing litigation. It is in relation to one failed finance company, a finance company clearly well known to the Minister because she knows at least one of his directors because she keeps appointing him to things. But no other trustee company appears to be caught up in the same net. So, sir, we do not see the need for urgency, and we think that considering this under urgency, all stages within a matter of hours, to be a highly improper use of that procedure and of this House and of the members of this House and the reputation of this House to act properly and democratically.
I call the honourable member Scott Simpson.
Thank you, Mr. Speaker. It's a pleasure to